Next will be discussed through 4 sections, which the first one is issue, the second one is law, the next is application, and the last one is conclusion.
Next, we talk about the question. Arthur works as a bouncer in a karaoke club Casablanca in section 3 Shah Alam. Last week, while driving home from work, he suddenly noticed thick smoke coming out from the karaoke building. Arthur quickly stopped his car. Without thinking, he broke a very expensive French door worth Rm 18,000 to climb into the nightclub to put out the fire. Marlene, the owner of the nightclub, was on a ship cruise at the time of the incident. She now demands that he pay for the cost of replacing the windows. Advise Arthur whether there is any basis under the law of agency which he can use to justify his action.
So I'm taking part of introduction. For introduction is, the law of agency is a legal concept that defines a relationship between one party with another, which is the principal and the agent. In this case, the provision relating the agency can be found in the Contract Act 1915. The Contract Act is important in legal system because it provides a framework for the formation and enforcement of contracts. The law of agency encompasses various modes of operation arising from specific situations, each allocated a specific section within the Contract Act provision. The modes of operation consist of express appointment, implied appointment, necessity, or emergency. Last but not least, every transaction occurring essentially an interaction involving the principal, agent, and the chosen third party entering into the contract. At the same time, each agency or contract execute become legally valid when all parties involved obey to every condition outlined in the agreement. This is the issue for question 7. Could Arthur legitimately justify the expense of replacing the damaged French door in the light of agency law? And did he have the legal right to serve as Marlene's agent and Casablanca nightclub?
According to Section 142 Contract Act 1950, an agent can be appointed during an emergency even in the beginning. The agent is not appointed by the principal to act on his behalf. This type of agency exists without mutual consent. For example, in emergency, an agency of necessity is created under emergency and is covered under Section 142 Contract Act. Due to this issue, an agent has the authority in emergency to do all such as to protect his principal from loss as would be done by a person of ordinary produce, in this case under similar circumstances. There are 4 conditions of necessity that must be followed. First, they must be real and actual emergency. Second, the agent's action is necessary to prevent loss to the principal, or the agent was entrusted with the principal property or goods. The principal or the property entrusted to the agent must be at risk of loss before the agent can act. Third, the agent cannot get the principal instruction at that time. In emergency, the agent must not be allowed to ask the principal for orders.
I will explain the application for this case. The first condition to be met to determine whether Arthur and Marlene's relationship fall under agency of necessity is that they must have had in existence a contractual relationship. The only form of relationship that is, however, seen between Arthur and Marlene is that Arthur worked as a bouncer in a karaoke and Marlene the owner of the nightclub. They do not have any contractual relationship, so one can say that the first requirement has not been met. The second requirement was there was an actual emergency. Arthur brought an expensive French door worth Rm 18,000 to climb into the nightclub to put out the fire, and if Arthur had not took an action, the fire would spread out to other people. One can safely say that the second requirement of necessity was met. The third condition is that it must be possible or impracticable to communicate with the owner of the nightclub, Marlene. From the scenario, it is seen that Arthur could not communicate with Marlene because Marlene was on the ship cruise at the time of the accident, so the third condition is met. The final requirement is that the plaintiff should have a good faith. Arthur evidently acted in a good faith because he acted without thinking just to put out the fire in critical situation. That's all. Additionally, this case can be referred to Great Northern Railway versus Southwest case. In this case, the railway company Ventis has been entrusted to deliver a horse of the defendant to a destination. But when it arrived, nobody came to take the horse. Ventis then took care of the horse to preserve its safety. Ventis claimed the expenses to the defendant, but the defendant refused to do so. It was held that Ventis was agent of necessity and entitled for the claim.
Today, I'm going to talk about the conclusion. As the conclusion, R2 has the right to prove that he is not guilty, and this can be referred in Section 142 of the Contract Act 1950. In this situation, R2 as an agent has a reasonable justification for his action. This matter can be referred to under the concept agency of necessity or emergency, where his action fulfills the condition of necessity. This situation can demonstrate that R2 action regarding the premise owned by his employee, Marlene, were not wrongful. Therefore, Marlene cannot demand any compensation from R2. Instead, as the employer, Marlene should acknowledge and commend R2 for his courage in saving the premise from experiencing more significant losses. Thank you.